Welcome to episode 74 of the Business SOS podcast. This is Rich Sierra, President of Florida Small Business Legal Center. We'll have a continuation of our last episode that we had with Angela Neave. She's still with us. I'll be flipping the script again, and I'll be the one being interviewed, while Angela will be the host today for Business SOS podcast. Angela, take it away.
Thank you for having me, Rich. I know that the last time we were here, we talked about mistake number 4, which is signing a lease without an attorney reviewing it. And I know we talked about that because that's mistake number 1 I made. And another one that jumped out at me as I was reading your book was mistake number 3, which is defending a lawsuit without an attorney. Mm-hmm. And it jumps out at me because I am also an attorney, and that happens all the time. I get many consultations coming in to meet with me, and they opted to represent themselves in their divorce, and now they need me to fix what happened. So I'm imagining that comes up for you.
Yes.
That's why you've written the book. And how many times a week would you say you have a consultation or a business owner calling you to fix a problem because of a lawsuit?
At least once a week.
At least once a week?
Yes.
Okay, so typically when they're calling you, what are they saying to you? What are they telling you?
Typically what happens is that they get sued, and then they file something with the court, some type of defenses or a letter to the judge, which is very common. And then, corporations and business entities in Florida must have counsel to be represented in court. So business owners usually have an LLC or a sub-S corporation, and then so they sue the corporation and they sue the LLC. So when the business owner files this response, then what happens is the opposing counsel files what is called a motion to strike pleadings on the basis that they have to be represented by counsel. Mm-hmm. So the court strikes the pleadings and then gives the business owner like 30 days to find an attorney, and that's when I get called.
So, when I read this, that I've heard about that for the first time. So let me ask you, why is it that an entity is required to hire counsel?
It is Florida law.
Okay, just Florida statute says
Florida
must
law.
do this.
Yes, yeah.
Okay.
Yeah, it's just the Florida law, and it's the case law, and it's just basically because an LLC or a corporation is a separate business entity.
From the person?
Yes.
Right, so my law firm is a separate entity from Angela Neave.
Correct, yes. With the exception of small claims, anything above small claims, the entity cannot represent itself in a court proceeding.
Interesting. So what's the limit for small claim?
$8,000.
All right, so if I get sued for $7,500, I can go into small claims court and represent myself. But if I get sued for, let's say, $30,000, I need to hire counsel to represent. And when I say I say the business. The business needs to hire counsel to represent it.
Yes.
Let me ask you this. So I have a question. Would the firm need somebody to represent it, and then would I separately need counsel to represent me, or could we have the same attorney?
You have an exception if you're an attorney. So
Okay.
you can represent the firm.
Oh, interesting.
So
Okay.
it's different in our case.
But let's say I'm not an attorney.
Yes.
Because a lot of your business owners are not attorneys.
That is correct, yeah. The business owners must have counsel.
Okay.
They really have no choice, or they will get defaulted.
So I want to make sure I understand. What you're saying is because I'm an attorney, I can represent my business.
Yes.
I understand. But if I was not an attorney, but what about, is there a time when a business entity and the owner both need counsel?
Yes.
Tell me about that.
It is very common in breach of contract cases or when somebody's claiming fraud. Usually when you have a breach of contract lawsuit or some type of contract dispute, it is very common that they add a fraud claim, whether it's fraud and inducement claim or negligent misrepresentation claim, or in the case the owner guarantees performance or a debt. So the owner sometimes gets included in that lawsuit. It's very common that you have the company and the owner.
Okay, so only if that happens, if the owner is being sued and the company.
Yes.
If the owner is not being sued in the lawsuit and it's just the company, you only need one attorney.
Well, you can have one attorney for both. If there's no conflict of interest, you can have, I represent cases that the company and the owner are being sued, and I can represent both of them. There's really no conflict of interest in this, and that they're both aligned.
What's an example of a conflict of interest that would require two different attorneys?
That's in the case of family law, for example. it's very common for husband and wife are being divorced, parties are being divorced, and then they have a business together.
Mm-hmm.
Okay, so the business usually gets sued as well for partition or division of property. So the business needs a separate attorney for that family law case, that divorce case, separate from the parties.
So I understand that. And I have in my career represented both a spouse and the business. But I understand the conflict because sometimes what's good for the spouse is not necessarily good for the business.
Correct, yes.
So, for example, if I represent a spouse who is in a family-owned business and maybe they own it with their brother or sister or parents, and the business is involved in the lawsuit, oftentimes they get added as a third party so that the courts can order the business directly to provide discovery documents like bank statements or operating documents, anything like that. It might be in my client's best interest to produce all of that stuff, but it might not be in the company's best interest to produce all of that stuff.
Yeah, there might be trade secrets that the company want to protect. There's intellectual property. A common request that is made by the court and is when you have disputes like in family court and also in the partnership disputes is asking for a receiver.
Yes.
So that's where that's where an attorney will have to be rehired for that business to defend that particular claim.
So let me ask you, I understand that within the divorce realm. What if it's not a lawsuit for divorce? What if it's a lawsuit for a breach of contract? Do you often recommend there should be two different attorneys if the owner is also being sued?
Not much. If the owner and the business being sued for breach of contract, usually I can represent the owner as well, because they're interrelated and they're kind of come from the same transaction. When you have a partnership dispute, that the partners are going after each other, sometimes you might need a third attorney to represent the company.
Yes, because obviously those two are completely at
They're
odds.
at odds, yes.
And may not even be able to operate the business because they're so at odds.
Yeah. In most cases, usually you have the attorney representing one party, also representing the business. The other party does not object because usually they're kind of aligned because they both have to pay a separate attorney to do it, so it's going to be more costly for them. So they said, okay, you represent the company and the other party is fine.
Right.
But if the attorney feels that there might be a conflict of interest and interest in the company and the interest of the business owner is representing, the attorney might have to say, I have a conflict here. You might have to get an attorney to represent the company.
Okay. So one of the other things that surprised me when I read this chapter was this statistic, and I want to read it. 36 to 53% of all businesses are sued every year.
Yes.
That seems like a very high amount.
It is.
We are a litigious nation.
Yes. And unfortunately, that is the case, that as the longer you're in business, the likelihood is you will be sued at some point in your journey. It doesn't mean that it's justified. It doesn't mean that it's fair, but you have to be prepared for that. And the way you prepare for that is, obviously having good business practices to make sure that there's less likelihood of that happening, but also having insurance. So in the case you get sued, you have the ability to call the insurance company to come and defend that lawsuit for you.
So I know that you mentioned in the book that you had a client who was a gym owner and luckily had insurance. So can you tell your listeners a little bit about that situation?
Yes, the client got sued for somebody allegedly got injured in a exercise equipment, So, they, one of the first things that I asked him is, do you have insurance? And I said, I need to check on that. So he fortunately did. And I started the case, the representation of the case, and eventually insurance company took it over because it was related to the specific field that he was in, and the injuries were covered. It was a covered event under the policy.
So when you say the insurance company took over, they took over the defense of the lawsuit? Did they hire a separate lawyer?
Yes, the insurance companies usually hire local attorneys.
Okay.
That they already have, vetted, and they represent, their interests, and they have separate counsel to take over the lawsuit as the defense. And I just withdrew, and they took it over.
All right. So in that instance, you were able to then stop. You no longer needed to represent your client because
Correct.
they were then essentially substituting themselves in to manage the lawsuit.
Correct. And also worked out for the client because he didn't have to come with more out-of-pocket cost of hiring me and continuing the litigation while the insurance company took it over.
So it sounds to me like one of your pieces of advice would be have the right insurance for your business.
Correct.
So do you advise business owners as to what kinds of insurances they should have that go along with their business?
I'll go in general terms, with general liability, errors and omissions, professional malpractice. But what I do, I refer them to an insurance broker that specializes in providing those types of products. And then he or she can go ahead and provide and give them the information they need specifically.
All right, so let's say I'm a brand new business owner and I'm going to open my law practice, but I don't know what I'm doing. And I come to you and I say, you're a good friend of mine. Can you please tell me what do I need to be aware of? I know we've talked about the lease, but what other things as a business owner, and not just a law practice, but in any type of business, do I need to be aware of with regard to insurance?
Yes, and I'm going to preface that by a quite common question that I have is like, I want to make sure that I don't get sued.
Okay, so that's the question I need to be asking myself.
No, but it's... And
well, that's the question you're asking yourself when you talk to me.
Yes. They asked me, that goes into the insurance part of it. It's like, how can I want a contract that I want to make sure I don't get sued. And I said, that's just not possible. Okay. You can mitigate and protect yourself from the likelihood of being sued, but you can never prevent somebody from suing you because that is something you have no control of. So the way I recommend the clients doing that, obviously having solid contracts, in which all the terms and conditions are clearly outlined.
And they understand all of those terms and conditions.
But also in the policies of your business, whether it's retail, good business practices, but also in the case that you get sued, that you have the proper insurance coverage. In the event you get sued, you can call your carrier and they take over the defense of that insurance and if necessary, settle that case for you. For a business owner, getting sued can be financially devastating.
Right.
It's just, even if you're right, you can lose your business, and I've seen that already.
You can lose your business because of the cost of the lawsuit.
And litigation is a battle of resources.
Yes.
It's not what people see on TV that you file a lawsuit, you go straight to trial, and 30 minutes later. No, it is an 18-month process, which 90% of it is procedural. 90% of litigation is basically motion practice in which the clients have no control over. They have no idea what's happening. The attorneys are the only ones that have control over the process when it's motion practice, while they're paying for that. They don't know what goes behind the scenes on litigation. So and most business owners don't have the financial ability out of pocket to support a litigation for 18 months. That is just the reality. So what I try to do, I triage that. I said, what budget do you have? This is the budget that you have. So we're going to basically try to triage this, neutralize the threat, and then try to settle this and get you out of this as soon as possible. Because I already know that most of them will not be able to take this to a trial.
Right, to sustain. So many questions came up for me as you were talking about that. So I want to come back to the pitfalls of being self-represented and when business owners choose not to. And I think that they choose not to specifically because they know that this cost of litigation is so high that they're not going to be able to sustain it, so they don't even speak to an attorney. They automatically assume, I know I can't afford this, and if they know they don't have insurances, then they become self-represented litigants. So I want to come back to that. Because I want to ask you one more question about the insurance. So I know we've talked about insurances for a gym. You've talked about briefly here malpractice insurance for, say, an attorney. But what happens? I know that there are oftentimes doctors who do not carry malpractice insurance, and that's the standard practice for a doctor because is it the lawsuits are so high, the cost of insurance is prohibitive? What's going on there that doctors are not carrying malpractice insurance?
It's a combination of both. Their malpractice coverage is exorbitant, it's almost prohibitive. So they choose not to carry it, and I believe they put a sign in their offices say, we choose not to carry malpractice insurance, and it's up to you whether or not you want to utilize that physician. But that is physicians are a different category altogether. Most businesses can't afford insurance. I mean, the people that I work with can't afford it. It's basically maybe a retail store, might be somebody providing services, a consultant, and insurances are affordable for small businesses owners. Mm-hmm. And there are many business brokers that provide that. If not, you can go to Better Business Bureau, can give you one. If not, you can call our office. We can refer you to some. So for small business owners, a general liability insurance is not going to be that much in comparison to a potential lawsuit that comes your way.
So it's your advice to pay a little bit, even if you don't like the cost, pay it because it's worth it in the end.
Absolutely. It's peace of mind to having that ability to call and a carrier and say, listen, I have a claim. And you put in a claim there, they take the case over and they'll handle it for you. In the event that you do not have insurance or it gets denied, which happens often as well, in my office, I mean, we work with a number of finance companies that finance legal services as well, which is a creative approach to providing that, because as a business owner, if you get a lawsuit, you're looking at about $10,000 or $15,000 right at the bat.
Right. I oftentimes say when I'm talking about the cost of a lawsuit for divorce, people don't have a slush fund for a divorce. Typically, they are using their life savings to pay for this. So I'm imagining that's also true for your clients.
Comes out of savings, it's comes out of credit lines, or whatever.
Borrowing from a 401k or any other retirement plan. Correct. Or taking out a line of credit.
Yeah, correct. So when you look at that, you have limited resources to defend this lawsuit, and you have somebody going after you, and the road is like a really expensive toll road as you go through the turnpike. $1,000 every time you pass, it can get very expensive. Mm-hmm. So what I try to do is triage that and say, let's neutralize it. Let's try to get it resolved. Let's get you from this point to this point and try to go to mediation as soon as we can to try to get it resolved, because I already know that I won't be able to go the distance.
Well, so I read that, and you like to go to mediation early on.
Yes.
So tell me why you recommend that.
I love mediation. It gives the client control.
Certainly a creative way. There's lots of creative ways to resolve a lawsuit in mediation versus if you're having a judge decide. Yeah. The judges don't have as much leeway. They have to follow the law.
Correct. Yes.
Interesting. So why early on?
It's an opportunity. It's an opportunity to have an off-ramp. So a lot of business, the way I look at lawsuits, and I've done, over 1,000 of these, people sue when they get ignored or when they're pissed. So basically,
I can say that about divorces. I get it. I get it.
So that's when there's some type of animosity. There's something that happened along the way that really triggers somebody to go further and hire an attorney, pay the filing, pay the retainer, put that in writing and send it to court. There's a lot of steps to it.
Yeah, it's a big step, actually, to decide I'm going to pay an attorney to file a lawsuit against you, the business owner.
Yes. So
would you say it's emotional?
It's definitely emotional. It's an emotional decision. Okay. Yes, absolutely. So what I try to do is say, there are a number of off-ramps here. The first one is, let's try to get this resolved as soon as we can, because the parties have not spent a lot of money in the litigation. On
the discovery and all kinds of nonsense.
And I try to do it, if it's possible, for an answer. That way it can save the client money.
Even before an answer?
If I can do it. If not, we'll just move on and continue. But every opportunity that you have to resolve the problem without the client investing more into this litigation, the better it is for the parties. And
right, I understand. I'm oftentimes advising my clients before we spend money on discovery, because once you start spending all of that money, then you become invested in the outcome, even if you are the one doing the discovery, because then the client is thinking to themselves, I've already spent all of this money.
Yes.
If I stop now, then what? So I understand why you're recommending it early on.
And in some cases you can do it. Some cases you might need some discovery. Some cases you might have to do some motion practice to push the other side to be in a more open-minded position to listen and to reason. So there are different tactics and strategies to utilize. But the sooner you have mediation, it's an opportunity, because the clients have control of the process. Mm-hmm. And I tell them, this is your opportunity to resolve it. We don't have control of the attorneys to the mediation. We can guide, we can we can provide advice,
Right.
but we're not in control of the process. You are as the client. If it gets settled, it's because you decided that. If it doesn't settle, then we already know we tried, and then we got to plan a litigation budget for the next 18 months.
And do you tend to give a written litigation, I want to say estimate, that's probably not the right word,
Yes.
but okay, so how do you do that? How do you handle that?
Yeah, I develop a litigation budget worksheet that I keep adding to it as more things happen, and it kind of gives the client an idea of what type of expenses they can anticipate throughout the process of litigation for the next 12 to 18 months.
If they're choosing not to settle or haven't been able to settle the lawsuit in the mediation
Or
process.
if they cannot settle, there's some cases you cannot settle.
Right, if
because
one
the other
side is too unreasonable or the number they want is too high.
Yes. So I do that so they know really there's motion practice, there's discovery, there's depositions that we have to be taken. And I do that for two reasons: to really give the client a real world assessment of what they can anticipate, because they don't know. They only know what is on
Right.
TV. They know what they see in the ads, personal injury ads, basically saying you're getting $1 million,
Right,
give me
right.
your case, no recovery. It's just, it's very unrealistic, but because there's so many things happening behind the scenes with our profession that they do not know, this gives me an opportunity to tell them this is really what you can expect. And all these motions that will be filed or might be filed, if you say, I have 10 witnesses, okay, let's talk about those 10 witnesses, okay? Because we got to take up at least 4 or 5 hours to prepare for the deposition, okay? Then we need to take the deposition, might be another 4 or 5 hours, depending what I'll be deposing. There's a lot of documents that we got to review. There's a co-reporter that we have to hire. And guess what? We might have to order the transcript. So just the co-reporter and the transcript alone could cost you $1,000. And that does not include the attorney's time, and that's only one witness.
Correct. And you have 10 of those.
So you can add that up, and when people begin to see that, that's like, well, this is really more expensive, and 9 out of 10 times I don't have that type of money. I'm like, well, we have to develop a budget. As I mentioned before, there's some finance companies that I work with that provide litigation financing on a case-by-case basis, and that have really helped and saved some of my clients.
So the financing that you're talking about allows the company to pay your fee, and then your client then pays that company back, almost like a credit card or a private loan.
Correct. But the difference is that this does, one of them does not go in a credit report. It's more of a business type loan.
Okay.
That's for the business, and the other one is some bit that you can check whether what you qualify for. It's more of a lower amount. I think they have a maximum of $8,000, and you can find out how much you qualify for without having a credit pool.
That's excellent.
And in some cases, they qualify for a certain amount, whether $5,000, and that's the $5,000 that they didn't have in the first place that allowed them to defend part of the lawsuit and get them to a place in a better place than they were before.
Right. So they can at least have some, I want to say, leg up or some control over perhaps getting it to a place where now they can negotiate a resolution.
Correct. Yes.
Well, and, talking about that brings me to the question that I said we were going to get back to, which is,
self-represented.
Oftentimes they decide that they're going to represent themselves because they think it's going to cost too much. And would you recommend that?
No.
And why not? I mean, aside from it's always better to have a lawyer, what actually happens in a lawsuit? And I'll give you an example. If one of your clients drafts a letter to a judge and then files that, they figure out how to file it. Does the judge actually read that letter?
No.
Okay, so
the attorney does.
Yeah. An opposing counsel certainly reads it
Yes.
and will do something. But what are some pitfalls, or why do you suggest business owners avoid becoming self-represented litigants?
A number of reasons. Number one, you will lose.
Number one.
Okay, and I have clients that choose to do that path, and I get their own against their own best interest. I said you cannot. In a business litigation, now in my 20th year, I get to know who the attorneys are, which is a very small community. Like in family law, you kind of know the people that are very active. So I see a pleading from an attorney that I have litigated against in the past. So I know his style, her style. They're very effective. They're good at what they do. and then I see this client saying, I got to represent myself, I'm telling him, just don't do that.
Well, but why
You
is
will
that?
lose.
So I am imagining that part of that is they're waiving defenses they might have.
Yes.
So what are some examples of some defenses that somebody waives if they're not hiring an attorney?
Okay. Because they can start saying, they can deny some of the allegations, and that's usually the first thing to do. This is what it says in the lawsuit is a lie, it's not true. And this happens with pro se litigants too, as well, that are individuals, which makes it more problematic for me. When they do that, because they start giving a whole history about what happened on their own version, thinking that they're just going to read it and said, okay, we're good. I got it.
And,
okay.
that never happens.
Yeah, that lawsuit, the way it could have been drafted, it could have been subject to a motion to dismiss. And the problem is that when you file an answer to the court, I no longer have the motion to dismiss for any technical reasons because you already filed an answer. So you waive all your defenses that I could have raised at the time.
Even just to get the lawsuit dismissed.
Correct, yes.
Forget it if you're trying to raise defenses like a comparative fault situation or anything like that, or a countersuit even.
Yeah.
Interesting.
So by doing that, then you're making it more difficult for the attorney to represent you because I would have to undo what you did or fix it.
And is that always more expensive?
Yes, it is always more expensive.
Right.
It's more expensive. And but for those clients who feel that I cannot afford this, talk to an attorney anyway. Because there are different, South Florida, we have a good number of attorneys and they work at different price points. So, and if you can only work at a certain budget, there will be an attorney to be able to work with you as well. Or basically get you to a place of better negotiating position, which is what I try to do.
So I think it's also important for business owners to think about if you're going to be self-represented, the courts, at least here in Florida, are going to hold you to the same standard that they're holding that attorney, right?
Yeah, unfortunately, that is the case, yes.
So they're not getting any leeway because they're self-represented or they're not lawyers and they've never studied law and they might not know the statutes they're being sued under.
That is correct, yes. And small claims, the judges are a little bit more lenient. It's like the people's court, so they kind of they give the self-represented litigants, especially they're both self-represented, a little bit more leeway in terms of how the rules are applied. If one side has an attorney, they're not going to give leeway, and that's what happens here. If you're in a situation where you have a lawsuit or a demand letter that an attorney wrote and demanding something from you, the best thing you can do is get an attorney to advise you on that particular letter or lawsuit.
Well, I'm glad you mentioned that. So I think it's really important for business owners to understand sometimes some of the best money they can spend is in a consultation.
Yes.
So do you do those types of consultations?
Yeah, we do those consultations. Usually we provide 30 minutes at no cost. If it's something more complex, we charge.
Right, so let's say I receive a demand letter and I call you and, I'm a lawyer, I'm pretty savvy, but I don't understand what I need to do here. I can pay you a certain rate and you can advise me through it or at least give me the advice and talk to me about the particulars of my lawsuit, right?
Yes, and how to respond to it. What is the response that you should have with this demand? But what I try to do is really what was the origin of that dispute, how this began in the first place.
So you're going to get some history, a little bit of what's going on.
Yes, because every lawsuit has motivation. There's some motivation behind it. Sometimes it's because of something personal that took place between the parties. Sometimes it's a straight debt that somebody just couldn't pay, or So it is sometimes it's simpler, sometimes more complex. How did this happen in the first place? So that gives me an idea on how I'm going to respond.
So I want to go back to other disadvantages to representing yourself. I mean, the obvious one is that you're waiving certain defenses and claims that you might have. But do you think a self-represented litigant has the same advantages as, say, the business owner who has hired the attorney to represent them?
Oh, no, absolutely not.
So why is that?
We know the rules of court. In the analogy I give to my clients, I mean, they're experts at their field. You know, if you're a restaurant owner, you know the recipes, you know how to run a restaurant. I don't. So if, you know, don't try to go into, I hate the word sandbox,
Yes.
that somebody else is an expert at,
Yes.
because you will be at a tremendous disadvantage. It's the analogy, another analogy, as you know, I do martial arts. It's like going against a black belt and you're a white belt. You don't have a chance to do that.
Unless you're much bigger and can just
Yeah.
lay on top of
Yeah. Yeah.
essentially.
Yes.
Right.
But this is very technical. There are very technical aspects of litigation, and just that's something you should do. You also might be making admissions that you may not want to make in the process.
That's the other thing I was thinking of, because I'm keeping in mind the business owner who writes a letter to the judge to explain what happened. And they may not realize that in the process of writing that letter, they've just implicated themselves in something or something else. And now they're amending a lawsuit to add a new claim.
That is correct. And also another mistake that I see is that business owners sometimes want to negotiate with the attorney.
So I have heard of that. So tell me a little bit about that.
Yes, and the attorneys, again, we're skilled, and the attorneys are very friendly and want to work something out. Hey, I need your bank statements to take a look at this. And I've heard stories that people just start giving documents to the opposing side because they just requested them. And I'm like, why are you doing that?
Well, and there's a formal process for that.
Because he asked, he just wanted to work something out with me. I'm like, well, you should not be giving your bank statements.
Right, because that lets them know whether or not you have deep pockets. It lets them know where the money is being spent. And there is really a discovery process that they
Correct.
should be going through if they were represented by counsel.
Correct,
So
yes.
they're giving away their personal information.
Personal information, emails, they give all this documentation to the opposing side without even, the proper request for production of documents. And so if you have an attorney on the side that is, representing the party who's suing you, you're better off having an attorney representing you to properly negotiate any potential settlement or resolution. But don't do it out. You're already outmatched, and it's not going to be a fair fight.
Right.
So those are the things that I see happening. And again, business owners by nature are like to be problem solvers. We're self-reliant, and that's the reason we're into business by ourselves in the first place. And we don't like to ask for help, myself included.
Me too.
So that's our nature to do that. But once in a while, we need to recognize that might be a problem above our head, and that we need to ask for help, professional assistance, to help us, guide us, and get us out of the jam that we're in.
Well, so I love that, and I know that I am always recommending that people are represented when a lawsuit is filed against them. And I think you echo that sentiment and have talked about it for, hours. I'm imagining in your podcast that it's smart to be represented. And we only have a few minutes left, but what are some common lawsuits that small business owners are subject to? Just so that your listeners are hearing and listening, and if something comes up for them, they know, this is one of those things that Rich talked about. I got to be aware of this.
A very common one is breach of contract.
Okay.
Whether a party does not, I see that with software companies, and I see it also with online marketing companies. One party alleges that the software was not developed properly, or with maybe the marketing program was not successful, then they stop paying the bill, and then the lawsuit begins. I see partnership disputes. Those are very common when one partner, and partnerships disputes usually happen when the business is not making any money, or the business has too much money.
Oh, yeah, they don't know what to do with it.
It's extremes. So you have a partner that says, you know what, I think I did a great job. I'm going to go on a cruise and put it in the company's bill. They run the Amex. The partner's saying, why are you doing this? And then they're paying personal expenses from the business account, and the partner's not getting paid. And then animosity begins to rise, from the tension begins to rise from there. One partner saying, I'm carrying the load here, I'm doing all the work while you're collecting distributions, you're not helping me here. So that is very common, and then you have to dissolve the company. You have to, they sue each other for breach of fiduciary duty, breach of contract. dissolution of the company, sometimes appointment of a receiver. It gets very, very messy. It's like a business divorce.
Yeah, that's exactly what that is.
So that's a very common one that I see. I don't see too many negligence ones coming my way. I see some for indemnity with subcontractors sometimes that so does some work and the contractor sues the subcontractor if they get sued for some type of injury.
Or if they're not paid.
Yes, yeah. Or subcontractors suing develop contractors, GCs for not paying, for failure to pay.
Yeah.
But usually breach of contracts and partnership disputes are kind of like the most of the lawsuits that we see.
So a good piece of advice would also be have a very clear operating agreement to begin with.
Yes, if you're in a partnership, and most of the partnership disputes that I see, they do not have operating agreements or partnership agreements.
Yeah.
So have it in writing, have it done. It just keeps things clear. Otherwise, you default to the statute. You know, you don't want to do that if you can.
Yeah. All right. Well, I think we're out of time.
Wow. Time
I went very quick. Thank you for having me.
Angela, thank you again for being a host. We got to do this again.
I would love to.
Yeah, this is episode 74 of Business SOS. If you want to reach me, learn about my legal services, my website is floridasmallbusinesslegalcenter.com. Of course, you want to reach Angela Neave. What is your website?
www.neavefamilylaw.com.
Okay. And again, until next week, this is Rich Sierra. Remember that my goal is to help you succeed.